friends, welcome to Law and Looks. My name is Isha and I like to smoosh together law and makeup to talk about some of the more fun or interesting cases that I learned about in law school while doing my makeup. Quick disclaimer, nothing I say can or should be construed as legal advice. I cannot give you legal advice. If you need advice, please obtain your own attorney and seek legal advice from them, not me. Okay, let's get started. Today, we're throwing it back all the way to Marbury versus Madison. Some of you guys might remember this case from either high school or college if you went to school in the United States as establishing judicial review. Judicial review is essentially the court's power, the Supreme Court's power to strike down laws, legislative acts of Congress that are unconstitutional. So it functions, as we know it today, as a really good check on the legislative branch. But that wasn't always the case, as you learned in Marbury versus Madison. However, there's way more to the story than just judicial review. We got a whole lot of political pettiness. It all starts with the election of 1800. We have our incumbent president, John Adams. He's a member of the Federalist Party. Running out of concealer. He's going against Jefferson, who's part of the Democratic Republicans Party. Drunk History has a fantastic segment about the election of 1800. It's hysterical, but basically things get dirty. I mean, Jefferson, I think, Adams accuses Jefferson of, I don't remember the specific details, but somebody accuses somebody else of, like, sleeping with prostitutes. The other person accuses the other candidate of being a hermaphrodite. I think Adams at one point says, "Vote for me because Jefferson is dead." Like, he falsely makes newspapers print that Jefferson is dead, so you should vote for Adams because at least he's alive. It is like your classic modern day electioneering smear campaign. Just like these petty insults thrown back and forth. You know what really irks me is the concept that women are too emotional to be leaders, but here we have our founding fathers running around like a bunch of children hurling insults at each other. Anyway, so all that is happening. Basically, nothing has changed over the course of 220 years when it comes to elections in the United States, so I'm not sure if that's a comforting fact or not, but here we are. In the end, Jefferson loses. There was like a tie with Aaron Burr, but it's not important to this story. Jefferson has won. Adams is our lame duck president. So what does Adams do right before he leaves office? Well, this is where you might remember the midnight appointment, or the midnight judges. Basically, just 2 days before his presidency was to end, Adams appointed 60 new Federalist judges and justices of the peace, backed by a Federalist Congress who had created these positions under the Judiciary Act of 1801, and he just filled a whole bunch of judgeships with Federalist judges. The next day, the Senate approved all of these nominations, and all of their commissions were written out and then just like hurriedly sent to the Secretary of State, John Marshall, he'll come back to us, to be sent out. John Marshall got most of these commissions out, but some of them didn't get delivered. And amongst them was William Marbury's commission. William Marbury was from Maryland, and he was to be appointed a Justice of the Peace for the District of Columbia, I believe. His commission didn't make it out before Jefferson took office. Jefferson instructed his Secretary of State, James Madison, to not deliver these commissions. Why not? Well, I mean, they're Federalist nominations, so Jefferson doesn't want them in office. And also he argues they're void because they weren't delivered in time, so he's very sorry to Marbury and everyone else who didn't get their commission and can't take office, but tough luck. Actually, he probably wasn't sorry at all. But Marbury wants his commission. He wants to hold judicial office. So what does he do? He sues Madison at the Supreme Court, asking the court to issue a writ of mandamus, which is is basically an order from the court compelling Madison to give Marbury his commission. So the election happens in 1800. Jefferson takes office in 1801, and Marbury sues in December of 1801 after a few unsuccessful attempts to get Madison to deliver his commission. However, the Supreme Court doesn't hear his case until 1803, because the Jefferson administration just suspended the entire Supreme Court term of 1802. So Madison and all of the other cases that were pending before the Supreme Court had to wait until 1803. So the court finally hears this case in 1803, and the opinion is penned by the Chief Justice of the Supreme Court, Mr. John Marshall. Now, wait a sec. Wasn't John Marshall John Adams' Secretary of State? Why, yes, he was. John Marshall was appointed to the Supreme Court as Chief Justice in January of 1801. However, he completed his duties as Secretary of State until the end of Adams' term in March of 1801, and then assumed his duties as Chief Justice. There's a lot of criticism today about John Marshall not recusing himself from this case because he was the person who was supposed to have delivered the commission to Marbury, and he failed to do so on time, and he served as Secretary of State, so there was just like a lot of conflicting interests for Marshall in this particular case. However, at the time, it was perfectly reasonable for John Marshall to not recuse himself. Only judges who had a financial interest in a case would recuse themselves, and not even people who were angered by the end result of this decision brought up any criticism based on the fact that Marshall didn't recuse himself. But people still today argue that Marshall shouldn't have sat in on the case and wrote the opinion. Regardless, we now have all of our characters in play. Marbury, who wants his commission, versus Madison, who was supposed to deliver the commission, allegedly, Jefferson, our president, and John Marshall, our Chief Justice of the Supreme Court. Fun fact, Jefferson and Marshall hated each other, like irrational loathing. And they were cousins. I think there was some family politics behind why they disliked each other so much. Also, Jefferson said some bad things about George Washington. Marshall took great offense to that. I'm sure there's a bunch of literature out there. Founding Father history. Speaking of Founding Father history, let's not forget that they were some racist people, so support the cause. I'll drop some Black Lives Matter links below. Donate if you can. So Marshall is put into a little bit of a political dilemma. If he finds for Marbury and says that Marbury is due his commission, orders the writ of mandamus telling Madison to give Marbury his commission, Jefferson and Madison can just ignore it. The judiciary branch doesn't have any means of enforcement. That's the executive branch. The executive branch is controlled by Jefferson at this point. So it would just showcase that the court is super duper weak. If he finds that Marbury is not entitled to his commission, then he gives the Jefferson administration a political win. He doesn't want to do that either. Also, at this point, the court is seen as weak. The judiciary branch literally has no power. It's kind of on shaky ground. In fact, Jefferson once wrote that because the judiciary branch is so weak, he can think of no better place for his loathsome cousin, Marshall, than as a judicial appointee. He wants Marshall on the judicial bench because there Marshall would be powerless. That's how weak the court system is at this point in American history. So what's Marshall to do? Justice Marshall is a clever man, and he completely sidesteps this issue while giving himself and the Supreme Court an insane amount of power. How? Well, he asks 3 questions. First, does Marbury have a right to his commission? John Marshall answers this question with a yes. He says that the commission was signed and sealed, and delivering it was just mere custom. It was a formality. Therefore, Marbury has a vested legal right to his commission. Next, Marshall asks if Marbury has a legal right to his commission, does he have any legal remedy to obtain it? Marshall
Marshall also answers this question as a yes. Essentially, he says, where you have a legal right, you have a legal remedy. Marbury has a legal right to his commission, therefore he has a legal remedy to it. One of the most widely celebrated quotes comes from this part of the opinion. The very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. Marshall then also confirms that the writ of mandamus is the appropriate remedy for Marbury to obtain his commission. Okay, so far, Marshall is with Marbury. He says, yes, Marbury has a right to his commission. Yes, Marbury has a legal remedy to obtain his commission, and the writ of mandamus is the appropriate remedy. Then, he asks, is the Supreme Court the correct court to issue that remedy? This is where we gotta know. Marshall says that the Supreme Court is not the correct court, even though the Judiciary Act of 1789, as Marshall interprets it, gave the Supreme Court original jurisdiction over issuing these writs. Marshall strikes down that part of the Congressional Act by saying that it conflicts with the Constitution. Essentially, the court's jurisdiction, namely the court's original jurisdiction, as defined in Article 3 of the U.S. Constitution, only allows the Supreme Court to hear cases between states or cases involving foreign dignitaries. These are the only instances where the Supreme Court can practice original jurisdiction. Original jurisdiction meaning that the Supreme Court hears the case first, as opposed to appellate jurisdiction where the court would hear the case on appeal, meaning that all the facts have been tried at a lower court and the appellate court has the power to revise and correct the lower court's decision. Through striking down this part of the Judiciary Act of 1789, Marshall declares the U.S. Supreme Court's power of judicial review for the first time ever. Now, you can kind of go off in multiple directions with this case. There's an interesting federal courts tangent. You can swim down, jump into a rabbit hole of regarding federal court jurisdiction. That's a rabbit hole that nobody's been able to figure out as of yet. Also note that Marshall didn't come up with the idea of judicial review. The idea had been around for a few centuries, but it was the first time the U.S. Supreme Court struck down a congressional act. And you know, since then, judicial review has been used in a lot of super important Supreme Court cases, good and bad. Marshall does draw some criticism over his opinion. Some say that it's just a series of assertions that then come to this one conclusion. Other people say that he was trying to get to this point, this end result. I think he was looking for a prime opportunity to establish judicial review. It was an accident. I think he saw this case and said, hey, this seems like a good candidate for me to establish some judicial review here. Give some power to the court. Like I said, this is such an important case. You can pull at different threads and just go down like 17 different rabbit holes, end up in a different place. But as always, I'd love to hear your guys' thoughts. Do you guys remember this case from your social studies or civics class? If you're in the law world, do you have any hot takes on Marbury versus Madison? I love a good hot take. Did I miss anything fun or important in my retelling of the story? Drop it in the comments below. Oh, and whatever happened to Mr. William Marbury? Mr. Marbury never did receive his commission. That's okay. He did just fine as a banker, you know, being in the Federalist Party and all, to be expected. And so, while he never held judicial office, I think it's safe to say he turned out okay. Oh no, my battery's dying. Okay, quickly finish the song. And that, my friends, is Marbury versus Madison. Thank you so very much for watching. I hope you enjoyed the tale of Jefferson and Marshall and Marbury and Madison. Let me know what you guys think, and I will see you all next time. Bye!